Hello everyone, my name is Rachita Mathur, currently working as a legal intern at LEXCLIQ. So today I will be discussing on a topic proof of actual damages. So in this video I will be dealing with section 73 and section 74 of Indian Contract Act. Also I will be dealing with some cases and proof of loss or injury in case of liquidated damages. So, to begin with, under Indian Contract Act 1872, Section 73 and Section 74 that is provided for unliquidated and liquidated damages respectively. So, so from this we came to know that damages are of two types, that is liquidated and unliquidated damages. So, under unliquidated damages, it is being stated that these are those damages which are being awarded by the court on the basis and assessment of actual loss or an injury that has been caused to a party who has been suffering from a breach of contract. Whereas in case of liquidated damages, it has been stated that these are those damages which the party to the contract may agree to as a payment of a certain amount of a breach of a contract. Further, we will look at section 73 of Indian Contract Act. In that section, it talks about that the compensation for loss or damages has been caused by breach of a contract. So, when a contract has been broken, the party who suffers by such a breach is entitled to receive from the party who has broken the contract compensation for any loss or damages that has been caused to him thereby, which naturally arose in the usual course of things from such breach, or which the party knew when they made a contract to be likely to be resulted from a breach of it. Such compensation is not to be given for any remote and indirected loss or damages that has been sustained by reason of actual breach. Further, under section 74 of the Act, it talks about compensation for breach of contract when penalty is stipulated for. So, here in this section, when a contract has been broken, if a sum is named in the contract as the set amount to be paid in case of such breach, or if the contract contains any stipulation of by way of penalty, the party complaining the breach is entitled, whether or not the actual damage or loss is to be proved, to have been caused thereby, or to receive from the party who has broken the contract reasonable compensation exceeding the amount so named, or as the case may be the penalty stipulated for. So, the proof of injury or loss in case of liquidated damages, firstly, we will have to see the nature of damage. For the breach of contract, there should be some precondition to claim the same. There can be no claim for damages if there is no breach of contract between the parties. Secondly, to claim damages, the party making such claim has to establish that a loss has been occurred. So, to understand with some reasonable compensation has been agreed upon in case of liquidated damages if there is some breach of contract in respect of some loss or injury, and hence existing of such loss or injury is indispensable for such claim of liquidated damages. In some cases, the court have even demanded the party to prove that the degree of loss or damages suffered as a breach of contract. Further, there were some cases of proof of actual damages. They are like in case of Mola Bucks. In this case, the court has held that the court is competent to award reasonable compensation in case of breach even if no actual damages is proved to have been suffered in consequence of the breach of contract. Further, the court has however specifically held that in case of breach of some contract, it may be impossible for the court to access compensation arising from the breach. In such a case, the sum named by the party shall be regarded as genuine and pre-estimated, may be taken into consideration as a reasonable compensation, but not if the sum named in the nature of penalty, where loss in terms of money can be determined. The party claiming such compensation must have to prove that some loss or damages have been suffered by him. Further, In case of Oil and Natural Gas Corporation Limited versus Soap Pipes Limited, in this case it was being held that the term of contract are clear and unambiguous, stipulating the liquidated damages in case of breach of contract unless it has been held that such estimated damages or compensation is unreasonable, or by way of penalty the party who have committed the breach is required to pay such a compensation. However, in some contract it would be impossible for the court to excess the compensation arising from the breach, and if the compensation contemplated is not by way of penalty or unreasonable, the court can award the same if it is genuine, pre-estimated by the party as a measure of reasonable compensation. Thank you.